morning, everyone. Welcome. My name is Steve Austin, and on behalf of the Virginia Community Criminal Justice Association, I want to thank you for joining us for our webinar today entitled Unrepresented, Why Counsel at First Appearance is Critical. I represent VCCJA's Pretrial Advancement Committee, and I'm also the Director of Criminal Justice Services in Prince William County, Virginia. I want to thank the Miller Center at the University of Virginia today for providing us technical support for this webinar. Some of you may have joined us for our webinar series last year, also on important critical pretrial justice issues, and today's webinar is an extension of that. Today, we're going to have a very robust discussion on a very important topic that is relevant across the country. This issue is currently of great interest here in Virginia, and it's really part of the critical components of a fair and equal justice system. Today, we have over 225 participants registered from across the country, which demonstrates the importance of this topic at a national level. Counsel at first appearance is relevant in Virginia, mostly because our General Assembly has been looking at this. House Bill 2286 requires that local courts develop a plan to ensure that defendants are represented by an attorney at their first court appearance. And a study has been underway by a state committee and making recommendations to the 2022 General Assembly on costs, feasibility, and the logistics involved in this implementation. Through counsel at first appearance, defendants are given the opportunity to have a meaningful first appearance and have an opportunity to have their bail considered at this very critical juncture in the criminal justice process. In some instances, this can result in defendants being released on bail much sooner in the pretrial process, which has benefits for not only the defendant, but also the local criminal justice system. And of course, is very much linked to fair and equal justice, as I've said. Today, we're very happy to have a panel of experts who are going to share their thoughts, knowledge, and experiences on this important topic. The conversation is going to revolve around a national view on this topic, why counsel at first appearance is so critical, and the best practices for ensuring a fair and just criminal justice system, as well as the impacts of having attorney representation at this juncture for both the defendant and the impacts locally. We will hear about the research and trends and how counsel at first appearance can impact time that defendants spend in custody, case outcomes, short and long-term impacts for defendants in the criminal justice system. This will assist to demonstrate why access to counsel at first appearance is a key component of pretrial justice. We'll also hear from two practitioners in a state and local system who will share their individual successes and challenges on their efforts to implement counsel at first appearance. This will include implementation of the entire state in Michigan, and also a local effort here in the state of Virginia to implement counsel at first appearance. So it's going to be a very dynamic and robust conversation. It is very relevant, and we so much appreciate our panelists joining us today. And I would like to introduce our panel first. I'm going to go ahead and introduce all of them before they begin their presentations. I do also want to tell you that this is an interactive conversation. We want your participation. We want to take your questions. We will do it periodically throughout the presentation time as time allows, and we will definitely have time in the later part of the presentation for your questions. So I hope that you can do that and join us with questions. There's a Q&A feature at the bottom of your Zoom screen. So if you click on that, you can submit questions. We do have people moderating and will be giving me questions to ask. So to introduce our panel, first we have Matt Alsdorf with the Center of Effective Public Policy. He is the Associate Director at CEPP. He's an experienced lawyer and nonprofit leader whose work is focused on improving criminal justice policies and practices, particularly in the pretrial field. Matt is the founder of Pretrial Advisors and has worked with many jurisdictions on improving pretrial policies and enhancing delivery of justice. Michael Mrozinski is the staff attorney at the Defender Legal Services Division of the National Legal and Defense Attorneys Association. He supports the work of public defenders nationwide, as well as improvements to indigent defense systems through research, policy training, and technical assistance, and development of resources and toolkits to assist defenders. Barbara Klmiaszewski joins us from the Michigan Indigent Defense. She's a regional manager based in Saginaw, Michigan, where she has represented indigent defendants for more than 30 years. Barbara served as a criminal defense attorney of Michigan, board member for approximately 20 years. She regularly serves as a CDAM trial college trainer and is highly respected by members of the bench and bar. And last, but certainly not least, is Tracey Lenox. She's our chief public defender here in Prince William County, Virginia. Tracey has practiced law for 28 years, defending people charged with criminal offenses from across the spectrum of criminal law, from drug offenses to capital murder. From 2008 to 2019, Tracey served as a substitute judge in the General District and Juvenile Domestic Relations Court throughout the region in Northern Virginia. She served on the board of directors of the Prince William County Bar Association since 2019 and served as the president of the Bar Association that year as well. And like I said, she's now our chief public defender here. So I'd like to welcome the panel. Thank you all for joining us today. This is going to be an engaging morning, and we hope to hear a lot of good things from you, and we'll have a lot of good interaction. So first up is going to be Matt Alsdorf from Center for Effective Public Policy. So Matt, I'll let you take it away.
All right, can folks see the slides and hear me? All right, excellent. So it sort of falls to me today to, first of all, thank you for having me here. And it falls to me today to set the stage a little bit about our discussion. And the way I typically like to start presentations like this, and this is something that I think all of you know, but is kind of just stage setting or level setting around why are we talking about the pretrial stage in the first place. And I always go back to this quote from Caleb Foote, who was a criminal justice professor. And in the 50s, he said, pretrial decisions determine mostly everything. And that operates on, I think, two levels, both the micro and the macro. On the micro level, and we'll talk about this in a second, research shows that whether or not somebody is detained before trial, how they're treated by the system before trial, has a huge impact on the outcome of their case, their ability to defend themselves, their employment, their family, etc. But on a macro level, it's also true. So if we look at who is in our jails, what we see is that most people are there before trial. They are presumed innocent. They've not been convicted of any crime. And if we look at the growth in jail population, virtually all of it, 99%, has come from pre-trial people who are there before trial. So that is not to say that no one should be there before trial, but it is simply to say that if we care about who is in our jails, we should care about who is there before trial, who is presumed innocent and in our jail system. Oops, let me do, I gave away the answer, sorry. The question, which I like to call the $14 billion question, is, are we detaining the right people? $14 billion is kind of the best estimate we have as to how much primarily local jurisdictions spend housing people before trial. And so are those the right people? And the answer that I gave away is that I would say no. They aren't, generally speaking, the right people. And normally I wouldn't give an answer with this lack of subtlety. But the reason I feel comfortable saying no is that in a lot of ways, it doesn't matter what perspective you're coming from, where on the political spectrum you are, or what values you put at the top of your list. Regardless of that, when we look at who's actually in our jails, people just aren't happy with what that looks like. And I think of this, the way I refer to this is dual system errors. That means kind of on both ends of the spectrum, we're not detaining the right people. And as I'm sure you all know better than anyone, our jail data nationally is pretty spotty. It's, we don't have great, very accurate, detailed data. But to the extent that local jails or state jail systems have looked at who's behind bars, what they've found is that many of those folks are pretty low risk, charged with pretty low level crimes, and are there largely because they can't afford what I think most of us would consider to be fairly modest levels of bond. You'll see here on this slide a couple example studies from New Jersey and from Harris County, Texas, that show that, when they looked at who was in their jails, what they found is that a lot of people were there on low levels of bond. And I think we can infer from that the judges didn't intend for them necessarily to be behind bars. If you look at the Harris County study, over 3,000 people a year were kept in jail because they couldn't afford a secured money bond of $500 or less. Presumably, a judge isn't intending to keep someone in jail on a $500 bond. And these are just example studies, but that is what we typically find when we look at who is in jail nationally. And from a public safety perspective, we're not doing a great job. When I was, in 2011 to 2017, I was at the Laura and John Arnold Foundation, and we did a lot of research into the pretrial system and jail populations. And what we found is that for folks who would have been identified as being the highest risk of committing violent crimes, if there had been an assessment tool in place, half of them were being released before trial. So again, I just talked about the kind of low end of the spectrum. A lot of people are in jail. The high end of the spectrum, we're not actually detaining the very small number of people who pose a legitimate threat to public safety. And this has knock-on consequences or downstream consequences. Some other research that we did and that many people have done since then shows that if people are kept in jail before trial, they are much more likely to recidivate down the line, both before trial when they're released and once their cases are disposed of. And this is pretty actually intuitive, I think, in terms of what the causality is there. We can't prove this, but I think it makes sense. If you're held in jail for 4 or 5 or 6 or 8 days or months, you're very likely to lose your job. You could lose your housing, your family stability could become unstable. And so many studies have shown that pretrial detention actually is strongly correlated with an increase in arrest both before trial and after trial. Now, again, I don't mean to say that no one should be in jail before trial, but simply that we need to be thinking very carefully about who is detained and making sure that we're not detaining people unnecessarily. And this will surprise no one on this call. There are significant racial disparities in terms of detention rates. And it's costly. As I mentioned before, the best estimates right now, or that's actually a few years ago, are that we spend about $14 billion. It's probably north of that at this point. And annually on housing pretrial defendants. And also, as I mentioned, because of the recidivism impact, there is also a higher likelihood that folks detained will end up recidivating and then being held in jail or prison, which also costs money. So again, what we see is that regardless of your priorities, whether it's fairness, whether it's cost, whether it's public safety, we have a big problem about who is in jail before trial in this country right now. So who should be detained before trial? The US Supreme Court has said in a case called US v. Salerno that I'm sure many of you are familiar with, that in our society, liberty is the norm and detention prior to trial or without trial is the carefully limited exception. So why is that the case? There are a couple reasons, and these are really kind of fundamental, foundational principles in our legal system. The criminal justice system holds people accountable for what they have done in the past, not what we think they might do in the future. If I haven't been accused of a crime, you can't take me off the street and put me in jail unless you cleared a very, very high bar. But when people are accused of a crime pre-trial, what we end up doing is anticipating that they might commit additional acts and then detaining them because of that. And relatedly is the presumption of innocence. We all are familiar with this principle that people who have not been convicted are presumed to be innocent. And that means that there needs to, as I said, be a very high bar for detaining them before trial, taking away someone's fundamental physical freedom. So again, not that that can never happen, but that the norm needs to be liberty, and pretrial detention needs to be the carefully limited exception. So in theory, there we go. When is this decision made? When is the decision made about who should be detained before trial? Most states have constitutions and or statutes that indicate that there should be a detention hearing where a judge makes an in or out decision about whether a person who's been arrested is going to stay in jail while the charges are pending. But because of our reliance on financial conditions of release, in effect, in practice, the decision that determines whether somebody is in jail before trial happens at the first appearance, when a judge typically sets a monetary bond that a person can either make or not make, which means that at first appearance, their physical liberty, which is, again, the most foundational type of liberty, I think, if any of us defined freedom, that happens at first appearance. And I would argue, I think sort of the point that I'm driving at is that if somebody's physical freedom is at stake, then legal representation is necessary. And this isn't just about detention, but obviously many jurisdictions have electronic monitoring or other forms of supervision for people who are technically released, but that impair their freedom. And so legal representation, being able to represent yourself and make arguments as to whether or not you should be detained, whether or not you should be subject to conditions, is necessary. Oops, skipped here. So the US Supreme Court has not quite directly weighed in on this issue. In a case called Rothgary versus Gillespie County, the US Supreme Court said that counsel has to be appointed within a reasonable time after attachment to allow for adequate representation at any critical stage before trial, as well as the trial itself. The Supreme Court hasn't directly said whether or not first appearance is a quote unquote critical stage. So that means that states vary in their approach to this question. But as I was saying before, I think there is a very strong argument to say, given the implications of the decisions that are made at first appearance, that strong, competent legal representation is necessary at that stage of the proceeding. And there, as you know, there's been a lot of litigation in the last few years around bail decisions, bond hearings, et cetera. And an increasing number of courts have held as a legal matter that first appearance can be equivalent to a detention hearing if there is a decision being made about the amount of bond that you would have to pay to get out of jail, and that bond might end up detaining you in effect, that needs to be treated as a detention hearing, and the due process rights that attach or that would attach at a detention hearing should attach at the first appearances as well. And this would mean that legal representation, isn't just helpful, but that arguably it is legally required. So I will turn it back to Steve at this point to introduce our next panelist.
Thank you, Matt. So next up will be Michael Mrozinski with National Legal and Defense Attorneys to talk about more around the research and around publication that his association has been working with. So Michael, turn it over to you now. Thank you.
Thank you very much, Steve. Yes, again, my name is Michael Mrozinski. I'm a staff attorney with the Defender Legal Services Division at the National Legal Aid and Defender Association. Howard, I don't know if we could get my slides started. Thank you very much. So I will be talking about a paper that I co-authored entitled Access to Counsel at First Appearance, a Key Component of Pretrial Justice. The development of this paper was supported by a grant from the John D. and Catherine T. MacArthur Foundation's Safety and Justice Challenge. That report is available on the NLADA website. If we go to the next slide, see the link is there. I'll also put that in the chat so that you can access it from there. Let me go ahead and do that now. Next slide, please. So I'd like to start by framing the report within the goals that NLADA had in developing the guide. We saw this essentially as a tool for defenders, policymakers, and others to use in pushing for the adoption or improvement of counsel at first appearance or CAFA programs in their jurisdictions. In particular, we wanted to help them make the case for how counsel at first appearance reduces jail populations and improves systems outcomes. We wanted to share legal arguments, standards, examples from the field, and empirical data with defenders and other criminal justice stakeholders to help them promote CAFA in their own jurisdictions. And we wanted to promote recommended practices for CAFA to help jurisdictions at different stages of implementation. Next slide, please. My remarks today will go over a few topics on CAFA from a national perspective. First, I'll discuss America's growing over-reliance on pretrial incarceration and the problems that flow from this particular segment of mass incarceration. Then I'll discuss how providing CAFA is an effective way to address this crisis. I'll give an overview generally of the benefits we've seen from implementation of CAFA programs, then dive into research from a few different jurisdictions around the country, namely Baltimore, Alameda County, and upstate New York. Next slide, please. First, let's look at the problem of rising jail populations across the United States. Matt went into this a little bit, but I think that a lot of this bears repeating just because of the enormity of the problem. So about 1/3 of the 2.3 million people incarcerated in this country are held in local jails. And approximately 74% of the total jail population held for local authorities, that's about 465,000 people, have not been convicted and have been deprived of their liberty despite the legal presumption of innocence. Those who are held pretrial in local jails, in juvenile detention, so that's including those who are held pretrial in local jails, in juvenile detention, for psychiatric evaluation or treatment, in Indian country, or in federal facilities. Overall, about 556,000 people are currently being held without having been convicted or sentenced. Next slide, please. And today, there are almost 4 times as many people detained pre-trial as there were 30 years ago. This chart illustrates the explosive growth in jail populations since the 1980s, showing that the growth has been predominantly the result of incarcerating people who are accused of crimes and awaiting trial. And in the past 15 years, 99% of jail growth has been attributable to pretrial detention of people who are legally presumed innocent. Now, money bail is part of the cause of jail growth over the past 30 years, as the average bail amount has more than doubled in that time, meaning that fewer people can now afford the cost of their release from jail, really the literal cost of their freedom. Next slide, please. So people detained pre-trial we have found through research that people who are detained pretrial are likely to have long-lasting and harmful outcomes. So people who are detained pretrial are more likely to lose connection to employment, housing, and family. They're more likely to be convicted in their case. They're more likely to have a longer prison sentence, and they're more likely to be rearrested for new crimes. So in summary, jail populations have been exploding over the past few decades, which creates real problems for accused individuals and their communities, particularly for Black people and other people of color that have been targets of law enforcement activity. Next slide, please. Now let's turn a little bit to the research from the field on counsel first appearance. Unfortunately, I don't have time to go through all of the relevant studies. There have been several around the country, and I invite you to seek those out. There are new ones that are coming out really all the time. This is a burgeoning area of research, but today I'll look to highlight 3 studies, namely from Baltimore, Alameda County, and upstate New York. So when we look at the wide body of research from the field, in aggregate, we can see that CAFA produces better client outcomes. In particular, we see that clients will spend less time in jail, they'll have higher rates of release on the day of arrest, lower bail amounts, and higher client satisfaction if they're represented by counsel. And that last point really ties into the sense of procedural justice, which is the sense that the proceedings were fair, and there's kind of a more general sense of fairness in court. Next slide, please. CAFA also produces better system outcomes. So we see a lower likelihood of recidivism by people who are represented at first appearance. We see lower jail populations, less money spent on pretrial detention in jails, and fewer hearings. Next slide, please. So diving into the particular studies, one of the foundational studies on the effectiveness of CAFA was the Baltimore Lawyers at Bail Project, or LAB project. Now, through this study, a group of accused individuals in Baltimore was provided with counsel at their first appearance, and their case outcomes and personal opinions on their representation were measured against those of a control group that did not receive an attorney. So the LAB study found that people represented by counsel were 2.5 times more likely to be released on their own recognizance without paying bail, 4 times more likely to have their bail amount reduced, and 2 times more likely to be released on the day of arrest. So some really important outcomes in terms of whether you get an attorney versus whether you don't. Next slide, please. Now, people represented by counsel also reported having greater confidence in the fairness of their bail proceeding and greater willingness to comply with the court's decision. These findings are consistent with research on procedural justice, which shows that people follow the law when they believe they were treated fairly. Now, this chart has a lot more detail than I have time to go into now, just in terms of the time that I have allotted to me. But my slides will be available after the event, so you can peruse this data at your leisure afterward. Next slide, please. Another study that sheds considerable light on the impact of CAFA was done in Alameda County, California, which is where Oakland is. And that study was done by Impact Justice through the U.S. Department of Justice Bureau of Justice Assistance's Innovative Solutions in Public Defense Initiative. In this project, counsel was provided at felony arraignments in Alameda County with some fairly eye-popping results. So we saw through that study positive impact in 80% of cases that had representation by counsel at first appearance, saw an increase of almost 20 points in terms of release from custody. I believe that it was less than 1% up to 20% of people were released from custody at their first appearance. There's 83% success rate on motions made to reduce bail, 74% success rate on motions made to release on felony probation violations. And there was a reduction in custody time that resulted in a savings of more than $420,000 per year, just in the number of jail days that were avoided by having counsel first appearance and not sending people to jail unnecessarily as a result. Next slide, please. So to put that some of that information in visual terms, we can see the impact that CAFA had in Alameda County. Release at arraignment, people who did not have counsel were only released 0.7% of the time. If they did have counsel, that's up to 20.4%. There were 0.0% of people had motions to release filed in their cases if they did not have an attorney. That went up to 20%, 27% if they did have an attorney. So it's really those two metrics in particular really show the importance of having counsel and the difference that that makes. Let's move to the next slide, please. So the third set of studies I want to talk about comes from upstate New York. So in 2013, the New York Office for Indigent Legal Services, or ILS, awarded grants to 25 counties across the state to fund counsel first appearance demonstration projects. Researchers at ILS and the School of Criminal Justice at the University of Albany State University of New York selected 6 of those counties to study how they implemented new or expanded counsel first appearance programs and what outcomes this representation produced. These counties were selected for diversity of geography and demographics, and each implemented a different counsel first appearance program, which was responsive to local needs. So the researchers studied 3 of the counties to which it had awarded grants to determine the effect of providing CAFA. These 3 counties were anonymized in the published report and assigned fictional names, which you can see here: Bleak County, Hudson County, and Lake County. So the study's findings are summarized in these 3 graphs. And again, there's a lot of data here, but I can just kind of walk through some of the highlights. The findings show that CAFA had measurable and substantial benefits in reducing bail amounts, reducing the overall time that the accused spent in jail, and reducing the number of accused individuals who spent any time in jail. So in all 3 counties, the percentage of accused individuals who were free after their initial appearance increased. So the percent who were free after their initial appearance increased by 1% in Bleak County, from 70.5% to 71.5%. It went up by 20.8% in Lake County, from 58.9% to 79.7%. And in Hudson County, it increased 15.4% from 69.6% to 85%. So some varying, but still substantially positive impacts for CAFA there. Although Bleak County courts released fewer people at arraignment and set bail for more people as compared with pre-CAFA data, CAFA also increased 3-fold the likelihood that courts would set bail for a given accused person at under $500. So as a result of this study in 2017, spurred on by the success of the ILS-funded programs, as well as a number of court-mandated CAFA programs from the Hurrell Herring v. State of New York class action case that settled in 2014, the New York State Legislature passed a budget to fund counsel at first appearance statewide, which was an enormously positive step for the state. Next slide. So that mostly wraps up my remarks. In conclusion, I hope that you've gotten a good picture of what national research has to show us about the ongoing crisis of pretrial incarceration and the proven effectiveness of counsel at first appearance programs in improving outcomes for individuals, communities, and systems. Thank you for your time.
Thank you, Michael, and thank you, Matt. Matt and Michael have both done a good job of framing up the issue from a national perspective. Some good data on the research and how counsel at first appearance impacts not only individuals' liberty and what ends up happening with the case, but all sorts of things that are really around public safety, such as future recidivism and things of that nature. That's very helpful. We do have a couple of questions before we go on to our next presenters that have come up in the chat that I'd like to see if we could get answered. We have one from Quinn about commenting on Virginia's pretrial risk assessment instrument, the VPRA, and its effectiveness. Is it working and making the difference intended, or does it need improvement? I probably have comments or thoughts on that, but I'm going to defer to some speakers here. Matt, would you like to take that one? You're familiar with VPRA.
Sure. So, I will confess that my perspective on assessment instruments has evolved over the past decade that I've been involved in this work. I haven't looked recently at the research specifically on the VPRA. My understanding is it was developed rigorously and has good predictive validity. That said, implementing an assessment instrument doesn't change a system by itself. And I think that what is important, whether or not a jurisdiction implements a tool like the VPRE, is working with decision makers and stakeholders collaboratively to shift their thinking about who should be detained before trial. Because fundamentally, regardless of what an assessment tool says, typically judges can detain or set monetary bond at a level that results in detention kind of for whomever they want. And so giving judges a piece of paper that provides results of an assessment tool doesn't shift the system on its own. So I think what is important is, again, regardless of the quality or rigor of the assessment tool itself, what's important is working with the decision makers to help them understand what is the law about who should be detained and how conditions should be imposed, if at all, and the principles of release being the norm, detention being the exception, and that the least restrictive conditions necessary to mitigate any potential risks are the ones that are imposed. So I realize that that doesn't totally answer the question about the VPRE, but I think the context is really important, that tool or no tool, what's most important is helping judges, prosecutors, defenders, et cetera, really understand what the legal principles are and what the consequences of detention and putting restrictive conditions on people are.
Great, thank you, Matt. And risk assessments definitely do evolve and they change over time. And Virginia is no different. You know, we've been had pretrial has been significantly studied the last few years, and we are looking at our risk assessment now. And there may be changes in the future. There is some conversations preliminary right now going on about that. So, you know, it does evolve and things do change, but our instrument has been around a long time, and it has a pretty solid foundation. But that doesn't mean that there's next generations of tools and the research does evolve. There is a question that I'll just answer here about the PowerPoints. We will attempt to get those out to you. We have all your email addresses, so we'll try to send those. As long as the technology allows us to do that, we may have to make the file smaller, but we will send you the PowerPoints of all the presenters afterwards, as well as the video links. I just wanted to let you all know that. So thank you for that question, Shannon, Taylor, and Enrico. Let's see. Another question, maybe one of you might want to take, and then we'll go on to talking to Barbara, is how can defenders appear in court with having been appointed yet? Michael, do you want to take that?
Yeah, so I think that there are a couple different ways that can be done. And it's the sort of thing that will have to depend on the particular local system in terms of what kind of indigent defense system is placed. Some jurisdictions will just have a public defender staffing first appearances so that they're in the courtroom, they're available to represent whoever's coming in for a first appearance. And so they can be appointed on the spot to represent the client during the first appearance proceeding. There are also some other ways that jurisdictions have found, some creative ways to do this in Cook County, Illinois, in Chicago. I believe it was 2 or 3 years ago, the chief judge of the county circuit court issued an order that stated that anyone who is arrested, anyone who's in police custody, who says they want an attorney, the Cook County Public Defender's Office is deemed automatically appointed to that person. So it's basically a case of magic words. If you say you want an attorney, you have an attorney. So that there aren't those kinds of loopholes there aren't those kinds of obstacles to get over in terms of getting the attorney into the police precinct to see their client, getting the attorney in for first appearance. It's really some cutting edge practices in terms of early access to counsel.
Great, thank you, Michael. So next we're going to shift a little bit. We've heard the national level and the research. We're going to look at practitioner and the work that's been done. So really where the rubber meets the road, we'll talk to jurisdictions that have done this work. And we're going to first turn to Barbara Klmiaszewski from Saginaw, Michigan. And she's going to talk about the work done there. Barbara, as I said earlier, is a regional manager for public defenders and is going to give us a perspective of some of the work done in Michigan. So Barbara, please take it.
Thank you. Michigan is ahead of just about everybody in the country as far as implementing criminal defense reform in a lot of ways, and indigent defense reform specifically. The Michigan Indigent Defense Commission was created as a result of a lawsuit that the ACLU had filed regarding payment of attorneys for indigent defense and providing resources for indigent defendants. That ended up in the legislature authorizing a report by NLADA to assess what was going on in Michigan in terms of delivery of those services, which not surprisingly was a pretty overall negative report, and ended up with a creation of an advisory commission in 2011 and the passage of the Michigan Indigent Defense Act in 2013 that created our commission and authorized the establishment of minimum standards. Right now, we have 5 of those standards in effect, and one of the original 4 is counsel at first appearance. So we have a statewide mandate to provide counsel at first appearance, among other standards, but to provide counsel at first appearance to everyone as they come before the court for the first time. So this is our standard, counsel at first appearance and counsel at all critical stages. Counsel is to be assigned as soon as the defendant is determined eligible for indigent defense services, and that is before first appearance or not. Let me be clear about this. In most places, they actually don't assess the defendant before first appearance because it isn't cost effective to do that. If a system wants to do that, each system is allowed to set up their own method. And if a system wanted to screen before arraignment, they can do that. But essentially, everyone is offered an attorney even before the screening process takes place. So if you are eligible, then you are our standard requires that all critical stages that is provided. So what has happened is that generally, even people that ultimately may not qualify are getting that attorney at first appearance, which sometimes results in resolution of their case, sometimes does not. So the initial response to the standard is kind of captured here in this slide. Everybody wants to change, but when you get to who wants to change, it wasn't as enthusiastically received as one might hope. The result of this is that we have had a variety of levels of resistance, but before the standard went into effect, before our grants went into effect, we had some pilot projects. We had 2 of them that were funded by the State Court Administrator's Office, and both of those judges that had that in effect for the first year, I believe it was a year, they have written documents about why this was a really great thing for their courts. And in fact, one of them absolutely insisted that he was never going to proceed without counsel at first appearance again. So when you look at the impact on judicial efficiency, I used to say that the people that aside from the clients, the people that liked counsel at first appearance the most were the court staff. But actually now I'd put them in the number 2 position, because the people that like it the most besides the clients is actually the jail staff. Because people that are in the jail and they don't know what's going on, and they don't know what's going to happen to them, and they don't know if they're going to get an attorney, and they don't know what's going to happen when they get to court, and they just don't know anything about what's going on. They ask those jail staff all the time a bunch of questions that they either don't have time to answer or they don't know the answers. Now they are contacted by their CAFA attorney before they appear in court, and just the fact of having those questions answered makes a huge difference. Another thing that is often really ignored about the whole implementation of CAFA is the other things besides setting bond that happen all too often at arraignments. People saying things they shouldn't say, people talking about stuff that they shouldn't be talking about. people asking questions that really can't be answered properly by the court. And even the most well-meaning judge will often have to basically shut the client up in order to prevent them from imperiling their situation. And I don't think we look at that enough, that the fact that they have an attorney that they can ask their questions of, that they can bring their situations forward before they actually appear in front of the court. This is a huge impact on the setting of bond, on the setting of bond conditions, and I think has a major influence on the whole operation of CAFA and the outcome operation. And therefore, it has a very positive impact on judicial efficiency and on the capacity of the courts to do this. Now, it does require a certain amount of flexibility by the courts in terms of scheduling, sometimes depending on the system, depending on the number of people that are coming up for arraignment. But one of the things that was kind of like a completely unexpected result, and it came, first we had the 2 pilot projects, then we had a rural county, Huron County, implement counsel at first appearance before they were required to under our standards. And very quickly, the judge noticed that there was a huge drop in the non-appearance rate. This was before the pandemic, but a huge drop, almost to 0, in the non-appearance rate for the second appearance. The fact that the person had their questions answered gave them confidence in what was going to happen to them in court. They were going to be given an attorney. They were given an attorney, and they just showed up. And the judge has documented this, that really they've just stopped issuing practically all non-appearance warrants for the second appearance. This is a very large impact on judicial efficiency. The cost of issuing that non-appearance, putting out the warrant, grabbing up the person the next time somebody runs into them from the law enforcement system, putting them back in jail, processing them back through for non-appearance. This is a huge thing to just drop out of the system. And we didn't exactly expect that as a result of CAFA, but it has proven to be the case quite soundly. Obviously, things have been impacted by COVID and people's access to the internet, because we've been doing a lot of stuff over Zoom and stuff. But so that's kind of changed that picture a little bit from that point of view. But it does speak to the fact that was addressed earlier, that when the defendant has the ability to have confidence in the system, when they have a different view of what's really going on here, and they realize that somebody is speaking for them and doing what needs to be done for them, they show up in court. So that has a huge value in terms of cost to the system. It has a huge value in terms of the defendant not getting caught up in additional legal problems as a result of their first legal problem. There's always been concern about attorney compensation, and I'll be speaking to that a little bit more in terms of how our grants have focused on that. We generally have had, because the way our statute is set up, the state pays 100% of anything that they're requiring that was not in effect before our standards were implemented. Each local system has established their previous contribution rate based on years before our act was in place. And so the attorney compensation for counsel at first appearance ultimately results in 100% funding by the state, because none of it was required before the implementation of our act and our standards. So the cost is on the state and not on the local funding unit. Next. This is a map of Michigan that is laid out, shows our 120 local funding units. Each of those funding units has to submit a plan to us for a grant each year, describing how they're going to provide counsel at first appearance, as well as implementation of all the other standards. This also gives you a picture of how we have divided up the state for implementation of our standards. Each of those colored areas is addressed by a different regional manager. I have that white section in the middle. And the reason that the size of the region geographically is so different from one to the other has to do with the number of courts. So it's really based on population density and the number of courts. So they're roughly the same number of courts in each of those regions. You'll notice that little region down there, it's sort of bronze colored down toward the bottom. That is Detroit, Wayne County, greatest number of courts, greatest number of people, busiest court in the state of Michigan. weighs the same as the entire Upper Peninsula of Michigan, as well as the northern part of the Lower Peninsula of Michigan. So we have dealt with the geographic challenges and the implementation challenges on a local basis because our statute requires that each funding unit submit a plan that addresses how they are going to meet the standards. So Counsel at First Appearance is one that we got a lot of grousing about it at the beginning, as was depicted in that cartoon earlier. And a lot of people thought it wasn't even possible to make it happen, but it's happening, and it's happening all over the state. Let's go to the next slide. This is the way our funding works. The blue is payment to attorneys. So as you can see, most of our money is spent paying lawyers to do their work defending indigent defendants. We have a different model for each system depending on what their needs are. We have public defender offices, contract systems, which are kind of on the phase out in most places, or have been phased out. And then we have managed assigned counsel systems. If you're not familiar with managed assigned counsel systems, this model is one where attorneys are paid to do the administrative work that courts have traditionally done, screening attorneys that will be on their panel, assigning attorneys to cases, paying attorneys for their services, and making decisions about things like the use of investigators or expert witnesses. So the managed assigned counsel systems, those functions are now completely independent of the court. We are right now in the process of implementing our fifth standard, which establishes that the court does not operate on any of those levels. They do not select the attorneys, they do not assign the attorneys, and they do not pay the attorneys, and they do not make decisions about experts and investigators. Those are all done independent of the court system. So the challenges that have been identified that we have worked to overcome over the last 3 years of our grant process include the geography. As you can see, we have a huge state and we have a lot of geographic challenges, which right now is in a lot of areas coming down to we just don't have enough lawyers. So if anybody would like to come up to Michigan, we got plenty of spots that would like to have more lawyers. Buy-in by the system, which, as I said, there's been a variety of levels of resistance to not only standard 4, which is the CAFA standard, but the other standards as well. But the more it's in place, the more it's liked. And it just kind of flipping back to some of the comments that were made earlier about the way defendants are treated at first appearance. I had a judge say to me, you know, traditionally when a defendant has come before me for arraignment and they have come with their attorney, I have treated it differently. I have listened to the attorney and I give that client a different break. Am I supposed to do that now that everybody's going to have a lawyer in the courtroom? The answer, of course, is yes, you are. And that's what they're actually doing for the most part. We do see that people are being treated more individually, that the bond decisions are being made more reasonably because the attorney is there to present the factors that will affect their bond decisions. The court rules, to the question that was asked a few minutes ago about how people can appear without being appointed first, we are about to have court rule changes reflecting that and some other things that are part of our system that reflect that an attorney can appear only for the purpose of arraignment. That's been being done all over the state, but we are about to have a court rule amendment that is going to solidify that as being a procedure that the court has to recognize. Eligibility screening, as I said, most places don't even pay attention to that. In fact, I don't know of anybody really that's paying attention to that before counsel at first appearance. But if they wanted to set up a system to do that, it would be okay. It would be within our standards to do that. Data collection is an ongoing challenge that we are still working on. And we are having increasing reporting and more accurate reporting, but we are certainly not where we want to be ultimately on that. There's a learning curve as to what is really at stake that has been an ongoing challenge, like when it is required to have it. Our position is if your liberty's at stake, you have access to an attorney. So there are situations where people do appear in court and they don't have their attorney with them. And these are situations where there's truly no liberty at stake. So in some instances, the first appearance is not really something where there are any form of bond conditions. They're just showing up essentially to get a date for their next appearance. They are still screened. They are still given access to an attorney, but the attorney may not be in the courtroom with them unless there is something in that situation that is going to affect their potential liberty. So if the bond conditions are a factor, then the attorney should be present. If it's a guaranteed PR release, then the attorney does not have to be present. So in some of the rural areas, we have addressed capacity issues by handling it that way. We've also had extensive use of Zoom. So sometimes the attorney is nowhere even close to the courtroom, and this was even pre-pandemic, this was being done, but certainly now during the pandemic, the majority of arraignments are being done over Zoom, sometimes with the client incarcerated, sometimes not. Some of these challenges have also been affected, and our outcomes have also been affected by some overall criminal justice reform in the state of Michigan that has reduced the number of arrests. The process on certain level of offenses, the protocol requires that they be given an appearance ticket rather than being taken to jail. So that has also affected a lot of the process in terms of counsel at first appearance. But resistance to change it's a fact now. Okay, the change is a fact, and so ultimately, if you are establishing it and you do it through a process that is going to incorporate these changes, fully embracing these changes, and fortunately, we've had the support of our legislature in adapting these changes, of our courts in changing the court rules, at least the leader.
Barbara, I think we've lost you. Okay. Looks like we have a little bit of a technical glitch going on. Okay. Can you hear me? Tracey, can you hear me?
I sure can, Steve.
Okay, sorry. It looks like we had a little technical glitch and we lost Barbara, unfortunately. So we'll let her finish. We'll let her finish when she comes back, and hopefully we'll manage that. We have a couple of questions. I think what we'll do is we'll go ahead and pivot over to you, Tracey, and let you talk a little bit about what's going on here in Prince William County. And then we have some questions that are in the queue that we'll address in a little bit. So Tracey, why don't you tell us what's going on here in Prince William with counsel first appearance?
Sure, love to. So I just wanted to start out by saying, giving kind of a bit of a bird's eye view for Virginia. This is in talking with the Virginia Indigent Defense Commission, is very strongly supports the attorney at first appearance, but it's not universal yet in Virginia, even in public defenders' offices. The differences across the Commonwealth of why some offices do it and some offices don't is really difficult to narrow down. It doesn't really seem to have a relationship to being urban, suburban, or rural. It doesn't really have a relationship to whether there's not much of a relationship to whether there's a public defender's office or not. And it doesn't have much to do with whether it's a more conservative or more Republican or more Democratic local government in place. So a little hard to know right now, but what we can tell is that what causes resistance to it largely appears to be just resistance to change itself, just like Barbara was talking about, and also just riffing on what Matt said about once you educate the stakeholders in the court system about the evidence basis for doing an attorney at first appearance, it's almost always embraced as effective once it's in place. That's been the experience from other members of the Virginia Indigent Defense Commission, other chiefs that I've spoken to about this. as I was preparing for this today. And it's embraced as consistent with effective, with good policy, as efficient, and again, as effective. So where it's resisted, it appears to be largely just like Barbara said, a resistance to being the change agent themselves, as opposed to change in a general way. And judges really seem to value, once they're educated about it and see it in action, these assessment tools, as well as having the value of having that advocacy at that first appearance. They recognize that it is actually meaningful to have both the VPRA tool as it exists now, as well as other factors that would be meaningful argued at that first appearance by an actual advocate. So let me turn to Prince William County now. In Prince William County, the evidence-based decision-making board has been in place for quite a while. And so some of the structural build out about evidence-based decision-making was already there. There was initial resistance from a number of the stakeholders in this, including the defense bar. And the defense bar resistance had mostly to do with counsel's own concerns about their financial considerations, whether it was going to decrease the amount of their income stream, whether it was going to create conflicts for them to do an attorney at first appearance and then be incapable of being hired by another attorney or by another defendant at a later time, because they had created conflicts for themselves by appearing. And then there was a big push in the year before I became president of the bar and into the year that I became president of the bar to try to get this program set up and move forward. And that was really, again, done out of the EBDM board, which has judges, the jail, defense bar, the Commonwealth's attorney, the clerk's offices. So all of the legal system, criminal justice system stakeholders were already at the table about this. And so the way it was developed, and I was intimately engaged in this, was to provide a carrot for lawyers because there was no public defender's office in this jurisdiction until June of 2020, and the attorney at first appearance got set up in late 2019. So the way that the judges orchestrated it to get attorneys to take on the attorney at first appearance duty was to give them an opportunity to be appointed to the individuals that they represented at the attorney at first appearance. So that was a strong incentive for court-appointed counsel to want to participate. If they didn't want to take on a particular case, for example, they did not typically handle violent felonies in the course of their work, they could decline the appointment. So they would be the ones making a decision about that. And so also there was some discussion. I contacted the state bar and got confirmation from the state bar that you can do a limited appearance at appearance at first appearance, and that limited appearance, as long as the individuals that were being represented were aware of the limitation of the appearance and signed off on that you could make that freedom argument for them at the first appearance without creating a conflict for yourself down the road. So we were able to get confirmation of that. That helped quite a bit in getting buy-in from the defense bar. And then we proceeded to have run a test run of it for a couple of weeks. The test run went really well. The judges liked it. They felt like it was meaningful to be getting that argument. And ultimately it stopped. And then the public defender's office came into existence, and we started taking over this appearance at this first appearance in September of 2020. And at the time, it was good that the office had been set up, because the problem that they had run into was that sometimes local court-appointed counsel wasn't reliably getting there in order to make those arguments meaningful or to make the arguments at all. So just operationally, so that you can sort of picture what this looks like in both in a place that doesn't have a public defender's office, which is Prince William prior to late 2019, and then afterwards as a public defender. The attorney of the day appears early for court. In our jurisdiction in General District Court, that would mean the individual would arrive around 9 o'clock, 8:45 or 9 for a 9:30 docket. There would be a vPray tool that our pretrial services provides to us for everybody that's going to be arraigned that morning. We would get the vPray tool and we'd sit down with it and we'd make notes based on what we looked at in the vPray tool. Sometimes if we were lucky, we would be able to look at the criminal complaint. Wasn't always available, but when it is available, it lets you know more about the nature of the offense and the allegations. And then at a little before 9:30, the deputy would get the video running. We would tell everyone that was there, hey, we're here to make an appearance for you and make a freedom argument for you. If you don't want us to do that, then just let us know. We won't do it. Also, if you, for some reason, you've already hired an attorney and you don't want us to make the argument, then let us know that and we won't do it. Then court comes in, the judge comes on the bench, we make the freedom argument based on what we've got in the vPray, and if we're lucky, based on what we know about the criminal complaint. And it's largely attorneys that have been doing this a while. And so you know what you're arguing about. You know, you're arguing about things that are going to bear on whether the person's going to return to court and whether the person is a risk to themselves or the community. And also you're arguing on reinforcing with the judge every single time you make the argument, the cost to the accused person if they're not released now, given the charges that they're faced. COVID, the one thing that we really would like to see done differently in Prince William that we haven't been able to do because of COVID is we don't have an opportunity to have a 2 or 3 minute conversation with each individual in advance of that first appearance argument. And that would be obviously super valuable because you would know more specific details about the individual that would aid you in making that argument. But it's just not been possible because we can't get access to our clients for even that small amount of time. When they're coming in, they're going directly into a quarantine unit in which we're not allowed onto. But that's the ideal for the near future. Just responding to one of the questions I saw in the Q&A, indigency of the accused is not a factor that is considered in this counsel at first appearance in Prince William County. We argue, the court-appointed counsel before us and now the Office of the Public Defender argue for freedom for every single person that appears regardless of indigency, unless they ask us not to, or in the alternative, if there is some reason for us not to do it. In Prince William County, for example, folks that are charged with a felony that are undocumented, and we don't always know if they're undocumented, but if you are undocumented and you're charged with a felony, the chances are that if you are released on bond, you're going to get scooped up by ICE. And so we would frequently, in cases where we could sort of make that calculation that the person might be undocumented, we wouldn't make a freedom argument. We would wait, go in, talk with the individual and get confirmation of whether the freedom argument is actually in their best interest or not. So that's operationally how it worked. Also, it's important to know that attorneys can bring bond motions after this. Attorney at first appearance does not prevent you from making another more meaningful argument later if you fail at the attorney at first appearance argument. So if I get up and I make all the arguments I can think of based on a vPray and my limited knowledge about the person or the accusation, I can still, after appointment, whether it's me or somebody else, gather that information from the client, from his family, from all of the other sources that I would gather bond information about, put on a bond motion, come back and argue it. And that is an agreed part of our attorney at first appearance is that it does not count as a bond motion. And then the thing I would also just sort of focus on, you've heard a lot about this, but there are enormous costs of incarceration. We calculate, I believe the current number is like $124 a day for a person to be in our local Prince William County jail. That's the cost to the jail. So there's that, the cost to the county. What we see, it's not anecdotal because it's thousands and thousands of cases. So I consider it more than anecdotal evidence. People they lose their jobs, and when they lose their jobs, they lose their housing and they lose their social connection. And they also develop a mentality of a trial penalty where they are more willing to just plead guilty to something to get out of jail if they're being held, even if they have good defenses. So that trial penalty is an incentive to plead just to achieve freedom. There's a reduced capacity to effectively defend yourself when you're incarcerated, just because it's difficult to make phone calls and talk to people and run down papers that might have some bearing on the guilt or innocence of the accusation. And then what's been alluded to, but I want to emphasize, is that there's a loss of actual fairness and due process that results in a systemic loss of faith in the system. And that loss of faith, loss of trust in the system is really disproportionately falls on Black persons and persons of color. And it's actually really destructive of the legal system itself. People who are held in jail without being convicted, who are awaiting trial, who don't get a meaningful look in the initial appearance in front of the court, almost universally have a strongly negative opinion of the fairness of the legal system and of the process, the due process that they are expecting to get and don't get. And that is super damaging to the system itself. So there's also one last thing in Prince William County. The attorney at first appearance has also been critical in giving effect to our local elected Commonwealth attorneys' commitment to reduce reliance on cash bail, and in fact to not ask for cash bail. In Prince William County, that's ostensibly the position of the CA, but having an attorney at first appearance is another advocate saying, Judge, we know cash bond doesn't work, doesn't have the effect that the court wants it to have. It's just a penalty. It's a poor tax. It's a penalty on poor people. And when an assistant Commonwealth deviates from the stated policy of the office, you've got the advocate there saying, Judge, this is not, it's not good. It's not best practice to be doing cash bond in a case like this. So that's the view from Prince William County and from the VIDC generally, and I'll hand it back to Steve.
And Tracey, thank you so much. And a couple of specific questions to Prince William. This is in General District Court, I think only that we're doing this right now. Is that correct? No,
actually, we also make these freedom arguments in the juvenile and domestic relations in the adult juvenile domestic relations court, and we make them at the detention hearing for juveniles, that initial detention hearing for juveniles.
So are we doing the attorney at first appearance for those as well? Is that what you're saying?
We do, and yeah, that's correct. The juvenile detention hearing, it's called something a little different, but it's the same principle of having an advocate in the room to make that argument.
And we started this around 2019. I believe there's a question asking about someone I think that was in this area said it wasn't happening in 2019. Is it something new? It is new, but was that the year it started?
I believe my memory of is it started late in 2019. I think it was in place. I think it was in place by late 2019. It might have been the beginning of 2020. It wasn't any later than that.
And I have one more question that can be for either you or Barbara. I think this is from Lacey. And Barbara, I'm going to come back to Barbara and let her finish up her presentation. So because she had a technical issue. Is someone going to address, this is from Lacey, is someone going to address how an on-the-spot appointment appearance can be truly meaningful? And in that vein, how it contributes to or detracts from perceptions of fairness and effectiveness of counsel in the system?
So I will absolutely answer that. And I think Barbara could probably also answer it, but it's not ideal because you don't have the opportunity to talk to the client and you don't have the opportunity to do the research that you would do at a full-blown bond hearing. Having said that, you still get your bond hearing. So it's not as though you're waiving a bond hearing in pursuit of just making an argument at first appearance. I believe that the numbers, and Steve, you might remember this off the top of your head, but I think the original data that we looked at was that we were achieving like 15% or so more release after the attorney of the day program was implemented. And as a result, that 15% has significant cost effectiveness. And I can make a pretty good argument for somebody based just on the VPRE. I can make an argument for somebody even if I don't have a VPRE. It won't be a very good argument, but any argument at all is better than no argument because the CA is in the room. They're making an argument. Whether the defense attorney is present or not, the CA is there asking the court on many occasions to not release a person or to release a person under conditions that are unacceptable or unneeded or unwarranted given the evidence. And if the CA gets to be in the room, then the defendant absolutely deserves to have an advocate there as well to argue for them.
Great. Okay, Barbara, I want to pivot back to you and let you finish up your part of the presentation. So sorry for the technical glitch. I know you were very close to the end.
Yes, I was. And let me speak to that last question too for a moment. In Michigan, we do expect the attorneys to talk to the defendant before their first appearance, even by a brief Zoom meeting or phone call to review their situation and their bond conditions. That is part of our implementation, is definitely talking to the client ahead of time. So that's part of our program. I just wanted to talk a little bit about how do we know that places are really doing this. We do require quarterly reporting from each funding unit, both for their financial reporting and for their compliance with our standards, which includes counsel at first appearance. We also do court watching both in person and over Zoom. For those that are still on Zoom, we've got mixed media for our courts right now. Some of them are doing Zoom still, some of them are not. Some of them are doing them partially in person and partially over Zoom. So like there may be some people in the courtroom and some people not in the courtroom. But in either case, we are doing ongoing court watching. We also visit as much as possible each place to make sure that they are complying with our standards, including this one, we were doing a lot more of that pre-COVID. We are cranking it back up, but we are careful to protect ourselves. So sometimes it's not happening as rapidly as we would like. Makes a huge difference when you're showing up to find out whether this is our regional manager system is designed so that we can visit our funding units and find out if they are meeting the standards with the grants that they're receiving from us. And we are also getting data from the State Court Data Warehouse in terms of the number of cases and their dispositions. And we have our research director is assisting in compiling that data to help us figure out where we're going with compliance with this standard. Before MIDC had these standards in place, there was one district court that was providing counsel at first appearance. About 3,000 people a year were being represented at their first appearance. After the implementation of Standard 4, which occurred during the grant year of 2019, we have counsel at first appearance provided statewide, and we've had about 205,000 people provided counsel at not only first appearance, but all critical stages annually. So we have research ongoing. Most of this has not been completed, but we are doing standards evaluation within our agency to evaluate the implementation of our minimum standards. The Right to Counsel project is doing a 2-year project to study the outcomes and costs associated with CAFA and developing a cost-benefit analysis. And the Urban Institute is also, they're evaluating our implementation process with our standards. All of those research projects are in final stages, really, and we should be publishing those within the foreseeable future to kind of give us a better picture of where we are with carrying this on. I did want to just say a little bit too about the different methods of implementation, and I know there was at least one question about that. This varies. This really, our system is set up to do local implementation according to the each system's abilities and needs. So we have people that are contracted to do only counsel at first appearance. This addresses that question about not PD offices. We have in some rural areas, we have a panel of attorneys that rotates. They might take a week or they might take a day in which they're representing anybody that is being arraigned at that time. We have public defender offices that are handling all of them. A lot of times the public defender offices, even in mixed systems that also provide panel attorneys, they kind of like having the first appearance because they can do some sorting and some conflict resolution early on in the appointment process. So that assists with that. We have people we have counties where we don't have any attorneys at all. So we have a lot of places that are doing Zoom appearances. So what we have done is required each county to come up with a system of providing counsel at first appearance, and the regional managers work with each individual system to reflect what their needs are and ways that they can implement this. So it isn't always simple, but we have figured out in every single jurisdiction a way to provide counsel at first appearance for every defendant. So that's it, unless there's some questions for me.
Thank you, Barbara. We have a few more questions. We've moved through our 90 minutes rather quickly. We got about 10 minutes, a little more than 10 minutes. So we go take a couple more questions in the chat. I see some questions. And if everyone can join us back, Matt, you can turn your camera on if you like, and we can see you. And we'll take some questions from everybody. Let's see. Here's a couple of questions around. I think funding is kind of an issue. So from Jamie, can the presenter speak to how funding of CAFA hourly versus stable via public defender's office impact case outcomes? Any thoughts about that?
I'm not sure that the hourly versus the public defender actually does have an effect on the outcomes. I don't know how closely we're tracking that, but it's clear that the provision of CAFA does affect the case outcomes. I don't know that which way that you're doing it affects the case outcomes.
Here's another question from Casey for whoever wants to take it, probably Barbara or Tracy. How do you maintain your credibility with judges? Are you arguing release on a child rape case, on a violent case? What does that look like? How would you avoid having the judge simply begin to ignore you because they know your argument is release, release, release? Come on, you never hear this.
Yeah. So no, this was actually one of the issues that our attorneys were worried about initially. And the fact of the matter is that sometimes you don't make an argument. If you have a person that's charged with first-degree murder, you might decide to tell the court that you're going to withhold until you have a chance to look a little bit more. But it's not as many cases as you might think. There's very few cases that we end up deferring on. In cases that are like like the example, a child rape case, if I have access to the complaint, there's going to be things I could probably argue about there. Person not being a risk to the person or to the community, a late report, there could be all kinds of things. But yeah, of course, you're absolutely aware of it, but the attorney or the judge at first appearance knows what your job is. And your job is to advocate for freedom for the people that are coming in front of the court and to use the best arguments you have. But certainly you're aware of the things that you can't with a straight face make a realistic or a useful argument about. And so that's it. Yeah.
My answer to this question is that you handle it exactly the same as if you were retained to argue for that client. So whatever your strategy is, if you are the retained counsel, that's the strategy you are if you're the CAFA attorney.
Great, thank you. Here's a question around mental illness, and that is often a barrier, we know, at the pretrial stage because the issue presents itself and it's problematic for what to do. So have any of the jurisdictions from Kristen Hudak, has any of the jurisdictions found barriers to release due to an individual presenting with mental illness? What has been implemented to aid in increasing the likelihood of release?
Well, I consider counsel at first appearance a big assistance in this direction because the counsel should be familiar with whatever programs are available. Getting that person referred for mental health services avoids the unfortunate result of having somebody with mental illness just thrown into jail and kept there until trial, which is going to cause their situation to deteriorate substantially. And I think having counsel at first appearance and having some familiarity with the services available, they may or may not be able to get that bond at first appearance, but they're going to be aware of the problem. The person's going to get appointed counsel. Presumably that person can work on making closer arrangements to get the person released. Getting all that underway at the earliest possible stage enhances the likelihood of the person receiving appropriate services during their pretrial stage.
And that's been the experience in Prince William as well. It's useful to know early on in the process so you can get services in place, get the person out of jail.
Thank you. Question for Michigan. In Michigan, what is the time frame from arrest to first appearance in court? In the rural jurisdictions, is there daily court or is someone held for a couple of days before hearing? That's a big issue in Virginia. That's a big issue in Virginia because of the rural jurisdictions. I'm sorry.
Yeah, on felony cases, it's the next business day that they're to be arraigned. The misdemeanors sometimes are held a little longer, which I find, bizarre that you could be held on a minor charge longer than on a felony, but that's the way the rule is structured. So there may not be, the frequency is less on misdemeanors than it is on felonies in Michigan. So pretty much the courts, pre-pandemic, all of our courts were given access to Zoom. And so that was part of the reason for that, is because there's Zoom arraignments pretty much on a daily basis, even in the rural courts.
Excellent. Well, thank you, panel. You all have really given us a lot of good insight on counsel first appearance. I wanted to just give you a few minutes. We got about 5 minutes. So it's a minute or so each for you to wrap up and say anything parting that you would like individuals to know. We've had, I want you to know, we've had great participation today. We still have about 190 people on the call. We were well over 200 when we started, and so it stayed pretty steady. So you've kept people's interest. So this is an important topic, and it's going on in Virginia now. So Matt, would you like to start?
Sure. I mean, I think we've covered a lot today. I think that the key message that I want to deliver is just that we really need to think about excuse me, our legal values as Americans and kind of what we say in the Constitution, both the federal Constitution and state constitutions, and how to vindicate those rights. And I think that it is a hard argument to make that individuals who are facing potential deprivation of any sort of liberty, whether incarceration or restrictions on even travel, that they wouldn't be entitled to counsel. And so I really applaud everyone here for their interest in that issue. And look forward to, I think I've said in the chat, happy to share the presentation. I think that'll be distributed. If folks want to get in touch, my email is on the cover page of the presentation, and please feel free to reach out. Thank you.
Thanks, Matt. Michael, I'll turn to you.
Thanks. So I hope that everyone here has seen not only that CAFA provision is doable, but that it's effective, and that it's something that really all jurisdictions should be looking at as a necessary practice in order to further the cause of justice in their courts. I think that it's important to point out, I didn't go into this too much, but my paper does talk about this a little bit, that it's not enough just to pass a bill and say, okay, it's implemented. There needs to be some other things put in place in order to have successful implementation. So that can include allowing attorneys access to clients before their hearing, time to prepare for their hearing, fair discovery, privacy and attorney-client communications, particularly when first appearance proceedings are conducted by a video conference, as pretty much everything is being done. Not everything, but a lot of jurisdictions are doing it across the country right now, where the defendant and client are in different locations. So there are some other considerations to be put in place. I would say that Virginia specifically, HB 2286 looks like a great step forward in terms of advancing this cause. And I would encourage you all to take a look at it and getting in touch with your members in the House of Delegates and in the Senate if you haven't already.
Thank you, Michael. And Barbara?
I want to point you to our website, michiganidc.gov, where our standards are there. And so you can read the text of the standards. There's also a white paper that is written about the establishment of each of our initial standards. So the Counsel at First Appearance white paper might be of value to those that might be looking at implementing this. And I want to just be encouraging to you and say, don't be afraid. It seems like it's impossible. It's not. We've done this. We have 83 counties in the state of Michigan. Some of them have 0 lawyers. Some of my counties in my region have 0 lawyers. We're still providing counsel at first appearance. So don't be afraid. You can do this.
Thank you, Barbara. I think Michigan has some very great similarities to Virginia, and it's kind of how the state is made up. So that's a good point. Tracey,
So
you get the last word.
quickly. So I'm going to echo what Matt said, and that is that to the degree that we care about our due process and we care about the values that are embedded in the Constitution, for an attorney at first appearance, for most of our clients, our experience in Prince William has been especially for the indigent folks. This is the first time that they have been in front of a court, and they actually have an advocate. They have somebody fighting for them from the moment that they step in front of a judge, and they're in an adversarial position, and they are not alone. And it is critically important that that value be how they start out in the legal system and how the legal system approaches this. They should not be alone when there is the other side in the room advocating for their being held in a freedom situation. So it can't emphasize enough the systemic reason why we need attorney at first appearance.
Well, our time has ended and we're right on time. It does feel like that we just got this conversation started, but you all framed it so well, and looking at the legal framework and how this needs to happen and how it can happen and how it has happened in some areas. And so we really do appreciate all the panelists, Matt, Michael, Barbara, and Tracey, for taking your time to join us in this important discussion. And we do appreciate it. I also want to give my thanks again to the Miller Center at the University of Virginia. They're great for helping us with the technical parts of it, and they do great work there at the Miller Center as well. If you've not seen any other work, it is fantastic. And also I want to let you know that we're going to be sending you, as a registered participant, we'll send your the materials, the PowerPoints. We'll send a link to the video so that you can see it. It will be posted on Virginia Community Criminal Justice Association YouTube channel, but we'll send a link out to everybody that registered. And we just want to thank you all for joining us today, and hope everybody has a great day. Have a good one. Bye-bye.